No matter what type of business you may have, when it comes time for your company to sign a new lease, it's important to pay close attention to the provisions concerning assignment and subletting, also called subleasing. From the tenant perspective, the vast majority of commercial leases will have no right to terminate the lease early outside of a situation where the premises have been destroyed. So, in the event your company needs to get out of the lease before the expiration of the lease term, assignment or subleasing will likely be your only option. These provisions will also ordinarily apply in the event that the company is sold, whether it be by sale of equity or sale of assets. At the outset, it is important to understand the distinction between an assignment of a lease and the subleasing of a lease. A true assignment involves a tenant assigning 100% of its interest in the lease to a third party with the added benefit that the tenant is released from any further obligations under the lease. A sublease involves a separate agreement between the tenant and subtenant for all or a part of the lease space, with the tenant remaining fully liable to the landlord under the original lease. As you might expect, subleasing situations are much more common than true assignment situations. In either situation, though, the landlord will understandably want to restrict the rights of the tenant to hand over the premises to a replacement tenant. When entering into the original lease with your company, the landlord may have relied upon your company's reputation, or credit rating, or on a particular mix of tenants at the property. The landlord does not want to suddenly inherit a new tenant it knows nothing about. You as the tenant, however, will want some measure of flexibility, especially in a long-term lease. As the tenant, you should push for provisions that allow you to assign or sublet, without consent, to an affiliated company, a company with a certain amount of financial assets, or a publicly traded company. Landlords are almost always going to require consent to assign the lease to an ordinary third party, so it is important to negotiate terms that won't allow the landlord to withhold its consent for no reason or allow the landlord to receive a financial windfall by giving its consent. It is often tempting to settle for language that simply states the landlord's consent may not be unreasonably withheld, but the concept of reasonableness under Texas law is ambiguous, and what may seem unreasonable to the tenant may seem perfectly reasonable to the landlord. And by the time you make it to the courtroom to get a resolution in such a dispute, the opportunity to sublease the space will quite likely be gone. Landlords will often require the tenant to pay them any profit realized by the tenant from assignment or subletting. Given that the majority of assignment and subleasing situations are not going to involve the tenant making a profit, it may be tempting to gloss over these profit-sharing provisions, but they are in fact negotiable and close attention should be paid to them as they may also apply to situations in which you are selling the company. The tenant should not only resist any explicit provision allowing the landlord to take a percentage of the proceeds of the sale, but the tenant should also push to include language that specifically exempts the proceeds of such large transactions from these profit-sharing provisions. Overall, keep in mind that the extent to which you can successfully negotiate favorable assignment and subletting provisions, like almost all other provisions in the lease, will depend on the relative bargaining positions of the parties. But there's always going to be some room to negotiate with any landlord before the lease is signed. Whether you're thinking of signing a new lease or you already have a lease that you are looking to sublet or assign, a solid understanding of these lease provisions and meeting with counsel who is well versed in these issues will be crucial to your company's success.